Okay, looks like we are finally going live here. Sorry for all of those technical difficulties. Apparently, YouTube's live streaming system is completely broken. I was streaming to the correct key and to the correct link, and just had to use the new interface instead of the old interface, even though it says that, yes, we are using the correct stream key. We've done all of that about 16 times now, and what worked eventually was to switch over to YouTube's new live streaming system, which does not have the features of the old live streaming system. But enough of that. You aren't here for my complaints about YouTube's live streaming system. You are here to find out how Richard Liebowitz got sanctioned $10,000, and this is not in the Usherson v. Bandshell Entertainment thing that we've just been talking about in the last couple days, the video a few days ago. Someone is saying you have no sound. Could we confirm that we have sound or no sound? I see sound being transmitted on my
I
thing.
had
I
to mute
see
you because
your
I could
sound.
hear the, yeah,
Okay, so
I
we
could hear
do
the
have
echo.
sound. Okay, so now I'm just being trolled. Okay, so this is the Mick Rock case against Enfant Riches de Perez, which I believe is sounds like it's a French name, and I'm just going to call them Enfants. Defendants Enfants and Barney's New York filed a motion for attorney's fees and costs pursuant to 17 USC 505 and Federal Rule Civil Procedure 54D for sanctions against plaintiff's counsel Richard Liebowitz and the Liebowitz law firm pursuant to 28 USC 1927, which I believe is the frivolous lawsuit or excessively delaying or excessively increasing the cost of litigation, and under the court's inherent powers, for the reasons set forth below, defendants are granted $100,008.13 in attorney's fees and costs. Mr. Liebowitz and the Liebowitz law firm are sanctioned in the amount of $10,000, and defendants' requests for costs and fees is denied. So, let's go into the background here. If you aren't familiar with Richard Liebowitz, Richard has filed over 2,000 I believe they're all copyright lawsuits, and that'd be fine if his law firm was this massive firm that could handle 2,000 lawsuits, but it seems like he cannot because he has been sanctioned many times, so many times that the Southern District of New York seems to have their own case precedent for Richard Liebowitz sanctions cases. Let's see what the judge has to say in this one. Plaintiff Mick Rock, or Mr. Rock, or plaintiff, I like calling him Mr. Rock, that sounds fun, commenced this action April 11th, 2017 against defendants for violations of the Copyright Act. Mr. Rock alleged that he was the creator and rightful owner of a photograph of musician Lou Reed, and that this photograph was used on articles of clothing created and sold by defendants without license. Defendants, on the other hand, disputed Mr. Rock's ownership, citing the lack of evidence in the record indicating his registration of the photograph. Plaintiff produced no evidence that the photograph was registered or that a proper application was made and refused by the register, which is the other way that you can get into court. The only registration referenced by plaintiff was for the work Mick Rock Exposed, a book which included the photograph. However, the registration for this book explicitly excluded previously published works, and plaintiff and defendants agree that the photograph had been previously published numerous times dating back to the 1970s. Nevertheless, plaintiff filed a complaint alleging that the photograph was registered by the Mick Rock Exposed registration. After discovery was completed, defendants filed a motion for summary judgment on August 8, 2018. Plaintiff filed an opposition September 7, 2018. Defendants filed a reply. The court granted defendants' motion for summary judgment March 21st of last year. Because plaintiff did not establish that the photograph was registered or that a proper application was made out and refused by the register. On April 4th, 2019, defendants filed a motion for the instant motion, which is this motion, for attorney's fees, costs, and sanctions. Opposition was May 2nd, and a reply May 9th. And I guess the judge finally got around to it now. It happens sometimes. Defendants request an award of attorney's fees and costs pursuant to 17 U.S.C. 505. Section 505 of the Copyright Act provides that a district court may award a reasonable attorney's fee to the prevailing party. Fee awards under this section should encourage the types of lawsuits that promote the purposes of the Copyright Act, which include encouraging and rewarding authors' creations while also enabling others to build on that work. And that's from the Kurtzsang v. John Wiley & Sons case, the Dummies Books case. Courts should give substantial weight to the objective unreasonableness of the losing party's litigating position, and should also consider the frivolousness, motivation, and the need in particular circumstances to advance considerations of compensation and deterrence. Does anyone here think that maybe Richard Liebowitz needs to be deterred from anything? I think maybe he needs a little bit of deterrence. What do you think, Tech?
I'm interested in the timeline here. What's funny is that when I saw he's being sanctioned for not registering a copyright, I thought that this was the Usherson v. Bandshell case.
Me too. When I first saw it, I eagerly opened it to see what was happening in Usherson, and it was not Usherson.
It is not Usherson.
An essential element of a claim under the Copyright Act is the registration of the alleged material. Here, plaintiff did not hold a valid registration for the photograph. Plaintiff and his counsel knew, or should have known, that the photograph was not registered through the work Mick Rock exposed, because the book's registration explicitly excluded previously published works, and plaintiff admitted in deposition and in other documents in discovery that the photograph was previously published on numerous occasions. Moreover, even if plaintiff and his counsel were unaware that the registration did not register the photograph, plaintiff's counsel had the responsibility under Federal Rule of Civil Procedure 11, which is where the attorney certifies that they have done their due diligence, to ensure that the factual contentions in the complaint had evidentiary support. Finally, discovery and defendant's pre-motion letter made clear that the photograph was not registered. Nevertheless, plaintiff stonewalled discovery requests for relevant documents pertaining to the registration, and then claimed with no evidence that the registration mistakenly excluded the photograph, despite the record clearly indicating otherwise. And there's a footnote here. Plaintiff argues that the claims were objectively reasonable and raised unsettled, novel, and complex issues of copyright law. The judge says this is incorrect. Plaintiff asserts that there was a novel question as to whether the registration could qualify the photograph. While plaintiff did advance this argument in his summary judgment briefing, the court swiftly rejected it because it misinterprets a fundamental aspect of copyright claims. The work in question must be registered, and the 990 registration explicitly excluded the photograph from the registration. Now, this is before we had the ruling of Fourth Estate Public Benefit Corporation, so that's where it said that you had to have registration for any copyright case to be brought. So I'm really not sure if that has any effect here. We'll see if the judge addresses that or not. Plaintiff argues that defendants are not the prevailing party since the court dismissed plaintiff's claim without prejudice. The touchstone of the prevailing party inquiry must be the material alteration of the legal relationship of the parties. A defendant need not obtain a favorable judgment on the merits in order to be the prevailing party. Instead, a defendant has fulfilled its primary objective whenever the plaintiff's challenge is rebuffed irrespective of the precise reason for the court's decision. In this case, although the claims were dismissed without prejudice, the legal relationship between the parties was materially altered. After defendant's summary judgment motion was granted, plaintiff cannot bring copyright claims against defendants unless and until the photograph is registered. This difference is not merely procedural, instead it actually accomplishes something substantive for the winning party. This court finds that plaintiff advanced an objectively unreasonable and frivolous arguments in this case that this litigation did not enrich the general public through access to creative works. Moreover, plaintiff's litigation strategy made consideration and disposition of this case more difficult for this court. Given this litigation strategy pursued by plaintiff, the need for deterrence also weighs in favor of awarding attorney's fees. Moreover, as the court discusses in this footnote and below, The claim was largely meritless, which is a factor in determining or deeming the defendants the prevailing party. So, sanctions. Defendants also ask the court to sanction plaintiff's counsel pursuant to the law and the court's inherent power under 1927, 28 U.S.C. section 1927. Any attorney who so multiplies the proceedings in any case unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred because of such conduct. These sanctions should only be imposed when there is a finding of conduct constituting or akin to bad faith. Similarly, awarding sanctions under the court's inherent power requires finding that the offending party acted in bad faith, vexatiously, wantonly, or for oppressive reasons. To succeed on a motion for sanctions, either under 1927 or the court's inherent powers, the movement must demonstrate clear evidence that the offending party's claims were entirely meritless and, 2, the party acted for improper purposes. Any finding of bad faith must be supported by a high degree of specificity in the court's factual findings. They have a bunch of cites down here that we're going to skip. Mr. Liebowitz is notorious in this district for his litigation strategy. These then are all of the different Liebowitz cases in this district. And we're just not going to go over all this right now. But suffice it to say, Liebowitz has his own series of precedents in the Southern District of New York, including his own precedents for his own sanctions. As one judge recently noted, it is no exaggeration to say that there is a growing body of law in this district devoted to the question of whether and when to impose sanctions on Mr. Liebowitz alone. That is a scary prospect, guys, that an attorney would litigate so much and so poorly, I guess is a way to characterize it, that the judges have already created precedential opinions for that specific attorney. For the reasons stated below, this court joins several others in this district in imposing sanctions on Mr. Liebowitz for his conduct. Mr. Liebowitz had the responsibility to ensure that the photograph was registered before filing the complaint. Compounding this is the fact that when faced with the prospect of the defendants learning that the photograph was not registered, Mr. Liebowitz actively stonewalled discovery requests. For example, he failed to comply with Magistrate Judge Freeman's order to obtain and produce Copyright Office documents regarding the registration, and he failed to respond to multiple requests from the defendants for these documents. This led counsel for defendants to have to separately request and obtain the registration documents at their own expense. Courts may impose sanctions for misconduct during discovery, including for harassment, delay, or other instances of bad faith. After it became apparent that the photograph was not registered, Mr. Liebowitz then argued that the registration had mistakenly excluded the photograph. Not only did Mr. Liebowitz provide no evidentiary support for this argument, it also is plainly contradicted by the record, although painfully contradicted by the record might be a good one. How about we
a little bit of a Freudian slip there.
Yeah, a little bit. Plaintiff failed to produce... This is a previous order in this case, I believe. Plaintiff failed to produce any evidence indicating a proper registration for the photograph or a proper application resulting in refusal by the register, both of which operate as prerequisites to filing a claim under the Act. Mr. Liebowitz also argued that the registration for the photograph would have been rejected. Again, he provided no evidentiary support for this argument, and it too is plainly or painfully contradicted by the record. This conduct of failing to investigate the evidentiary basis for a complaint, of stonewalling discovery, of misleading the court, and of making meritless arguments undoubtedly demonstrates bad faith, which may be inferred where the action is completely without merit. Accordingly, the court finds Mr. Liebowitz's conduct in this case sanctionable under both Section 1927 and the court's inherent powers. Now let's take a look at the nature and amount of the sanctions. The two questions that remain are whether to sanction Mr. Liebowitz's law firm and the amount of sanctions. Because Liebowitz's actions were indistinguishable from those of his firm, the court imposes sanctions against both Liebowitz and the firm jointly and severally. Next, as to the amount of the sanctions, the court has the authority to hold Liebowitz jointly and severally liable to satisfy the attorney's fees award in this case. However, sanctions should not be more severe than reasonably necessary to deter repetition of the conduct by the offending person. District courts have the authority to not award the entire lodestar amount of the attorney's fees as a sanction. In Eastway Construction Corporation versus City of New York, the course of law concerning use of attorney's fees as one of an array of sanctions against frivolous litigation has recognized that a lodestar amount need not be routinely awarded. In this case, joint and several liability for the attorney's fees could be excessive if Mr. Liebowitz and his firm are held liable for the entire amount, or under-inclusive if the plaintiff himself has to satisfy the award of attorney's fees. Instead, a sanction of $10,000 is more tailored to serve the sanctioning purpose in this case. Wow. Accordingly, Mr. Liebowitz and his law firm must collectively pay $10,000 of the responsible person's attorney's fees or reasonable attorney's fees calculated below. And this is, once again, they cite 1927, any attorney who so multiplies the proceedings in case or court unreasonably and vexatiously may be required by the court to satisfy personally the excess costs, expenses, and attorney's fees reasonably incurred. Defendants seek $4,181.82 in costs, $160,000 in attorney's fees, and $20,000 to $30,000 of additional costs and fees, which I'm not sure what those are. For the reasons discussed below, applying a 25% reduction in hours billed by defense counsel and reduced hourly rates, defendants are entitled to $95,826 in attorney's fees and $4,181 in costs. Defendants are not entitled to the additional costs and fees associated with this motion. When analyzing a request for attorney's fees, a court must determine the lodestar amount, which is the product of a reasonable hourly rate and the reasonable number of hours required by the case, also known as a presumptively reasonable fee. Believe it or not, your attorney has a duty to charge you a reasonable fee. The fee could be higher, could be lower. If it is lower, the court can award the reasonable fee, what it would have been, which would be higher. If it is too high, the court will actually pare it down and award what the court determines is reasonable. The court determines the reasonable hourly rate by considering case-specific variables such as the complexity of the case, the amount of work required, the attorney's expertise, the awards in similar cases, among other factors. With respect to the reasonableness of the hours expended, the court looks to its own familiarity with the case and its experience with the case and its experience generally, as well as to the evidentiary submissions and arguments of the parties. Trial courts need not, and indeed should not, become green eye-shade accountants. The essential goal in shifting fees is to do rough justice. Wow. Just rough justice. You know what? We need to have a t-shirt with that on it. Rough justice. Not to achieve auditing perfection. So trial courts may take into account their overall sense of a suit and may use estimates in calculating the attorney's time. Reasonableness of hourly rates. Plaintiff contests the reasonableness of the hourly rates for all four attorneys in this matter. $913 an hour, $740 an hour, $750 an hour, and $613 an hour. Wow! I've got to up my rates. Holy mackerel. After a careful review of the record by defendants and the factors laid out, the court believes the following adjustments are appropriate. In another case filed by Mr. Liebowitz in this district last year, the court considered the hourly rates of the same people, it looks like. At least Slotnick and Chen. I don't see Pepper in there. Okay. And that was the Craig v. UMG Recordings case. There, the court noted that Barry Slotnick has over 40 years of experience in his position as a partner and chair of the Intellectual Property and Entertainment Litigation Practice Group at Loeb v. Loeb. Or Loeb, I'm so used to saying V. Loeb and Loeb. An hourly rate of $828 is reasonable. Similarly, for substantially the same reasons, the court finds that his $913 hourly rate is reasonable. Debbie White is a nationally recognized partner, is the deputy chair of the music industry practice at Loeb and Loeb, and has more than 20 years of experience litigating copyright issues. While she billed less than 4 hours in the case, her hourly rate is reasonable, $740. The Craig court reduced the hourly rate for Chen to $550, given her experience as a senior litigation associate, her experience handling a broad array of litigation concerning copyright and other intellectual property, and the complexities of discovery and litigation in this case. The court determines that an hourly rate of $575 is reasonable. Sarah Perry is a litigation associate with 5 years of experience and has handled copyright and trademark infringement cases previously. Her hourly rate of $400 is reasonable. Although the plaintiff does not object to defendants' proposed rates for paralegals and other staff, the court considers them anyway. Antoinette Pepper, okay, she's the paralegal, $420 an hour. Wow. Jerry Papa, paralegal, $425. Others are $235, $380, $390, $275. The research librarian is $325. The director of litigation support is $391. These rates exceed the reasonable hourly costs for similarly These rates exceed the hourly cost for similarly situated professionals in this district. So paralegals are pared down to $100 to $200 an hour. So that's $200 now for Pepper, Papa, and Cummins, and $150 an hour for McRae and Perez. The research librarian, $200 an hour. Wow. Next, the court turns to the reasonableness of the number of hours. Courts must examine the particular hours expended by counsel with a view to the value of the work produced and the specific expenditures to the client's case. District courts may make across-the-board percentage cuts in hours instead of engaging in an item-by-item approach. So, plaintiff argues the court should apply an 85% reduction because they are a grossly inflated amount for an AM 100 or top 100 law firm seeking to gauge its corporate client, or gauge? I think they mean gouge, its corporate client and insurance company. Plaintiff provides no specific objections to time billed by defense counsel. In this case, defense counsel was required to engage in contentious discovery, including motions to the court regarding plaintiff's noncompliance with discovery requests, opposition to defendant's pre-motion letters, and researching and drafting a motion for summary judgment and reply in for the support of this motion. However, defendants acknowledge that many of the motions they drafted and research they conducted was in response to meritless or easily disposed of briefs and arguments. Quote, opposition to plaintiff's meritless opposition to defendant's pre-motion letter, researching and drafting a reply to plaintiff's meritless opposition to this motion. This counsels in favor of a reduction to the amount of time that was reasonable to spend on this case. It was abundantly clear after discovery that the photograph was not registered, so that's a factor that weighs in favor of paring it down. And attorneys with the experience of defense counsel would not need to spend large amounts of time countering the meritless arguments put forward. Moreover, given the lack of complexity and evidentiary support for the arguments raised by plaintiff, the court is unconvinced that a partner and senior associate needed to spend over 150 hours in this case. Using multiple attorneys in a simple case, which this certainly was, poses the serious potential, fully realized in this instance, for duplication of work or overstaffing. Accordingly, a 25% across-the-board reduction is necessary to account for the scope and complexity of the particular litigation.
Oof. Court was not happy.
Yeah, court was not happy with that. And then there's a footnote 7. Defense counsel billed over $20,000 on the motion for summary judgment. Given the lack of evidentiary support for most of the claims made by plaintiff in his opposition to defendant's motion for summary judgment, the court believes that defense counsel expended more time than necessary in litigating what defendants have characterized as elementary problems in plaintiff's claims. Next, the court turns to the reasonableness of the costs, the $4,181 in costs. Plaintiff does not object to the defendant's cost calculation. The cost requests are primarily associated with the deposition to the plaintiff, $2,710, along with routine postage, legal research, and document production. Many of these costs and fees were made necessary by plaintiffs' failure to investigate and appropriately litigate this case, and the costs are reasonable out-of-pocket expenses incurred by attorneys ordinarily charged to their clients. Defendants have also requested an estimated additional $20,000 to $30,000 for costs and fees associated with the instant motion and reply. So this sanctions motion, I guess. When courts have the authority, or while courts have the authority to award costs and fees associated with motions for sanctions, this court declines to do so. The question of whether to impose sanctions and attorneys' fees was not so obvious as to make plaintiff's motion in opposition frivolous or meritless. So plaintiff's opposition in the sanctions motion was not frivolous. Accordingly, plaintiff's motion in opposition to defendant's motion for attorney's fees, costs, and sanctions does not cross the line between zealous advocacy and sanctionable conduct. So they don't get that back. So for the reasons set forth above, defendants are granted $100,000 and $8.13 in attorney's fees and costs. Liebowitz and his firm must collectively pay $10,000 of that award. So the client gets hit with $90,000. I keep saying it wrong, $90,008.13, and the rest of the request is denied. And this just dropped on the 29th, and that's why we're picking it up today. So what do you think of that, Tech?
I think one of the interesting things for this is that one of the reasons why senior lawyers can charge so much money is because their experience allows them to do things very fast. And it allows them to be very efficient.
Yeah.
And so the court is pointing out, okay, we're going to give you high per hour rates, but we're also expecting you to do this faster and streamlined and be efficient because of all of your experience, which I think is a good balance.
Yeah. So that is how Liebowitz got sanctioned for $10,000 in a case that we haven't even really covered yet. Like that, this is a case that slipped under the radar until this moment, and so we haven't been discussing it in our past 6 videos on Leibowitz's various sanctions. So remember, he got sanctioned by Judge Sibel, almost disbarred, but definitely referred to the grievance committee. He got disbarred out of the Northern District of California, I think it was, for not filing his pro hoc vice motions or getting his admissions done properly. And he is currently, sanctions are being requested in the Usherson v. Bandshell Entertainment case, and that's been pushed back into February. So we would have had that by now, but that's been pushed back to February. So we'll see if the judge wants to issue a sanction of disbarment there, or whether that'll just be another monetary sanction. And we haven't even seen yet about whether the state bar, the New York State Bar, or wherever he's base licensed, if they've done anything to take any action against him. We'll see if something like that drops as well. So let us know what you think in the comments below. This will post as a video on demand. I am Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel. Thank you for joining me today. Thank you for your monthly support. Don't forget, we need your money to keep this channel going, to keep improving our quality and quantity of content. And you can support us on patreon.com/ljfrench or sponsus.com/law. Thank you very much to our January $50 plus supporters: Apernari, John Steele, Gavin Barnard, Kyle Mudrak, Michael Pearce, Jan Negrey, Spirit Bear, Daniel Perez, Snorre Wisotzky, Blackleaf, Joe Tyson, Eevi, Benjamin Hitov, Steven, Cute Grills in your area, and Ottah. I really appreciate your support. The $5 plus supporters are in the description of the video. I'm Leonard French, your favorite copyright attorney. Joining me in the studio today was your favorite tactical bra, and I will see you in the videos that drop. Have a great weekend, everybody.